Ready for the next case, which is 18-1659, Boling versus WFTV et al. And of course, please take your time getting yourself situated at council's table. And whenever the appellant is ready, I just need to know how much time you would like in rebuttal. Okay.
Good morning. If it may please the court, Roderick Boling appearing pro se. The 4th DCA may have summed it up the best when quoting Longwood Medical Center versus Sadow in 43 Southern 3rd at 710. They quoted the 10 Commandments, saying, "Thou shalt not bear false witness against thy neighbor." In more recent and less eloquent terms, fake news can ruin people's lives.
Well, the 10 Commandments doesn't have a notice requirement. You do.
You are correct, sir. You're correct.
And did your notice specify the exact statements that you claim WFTV published that were defamatory?
It did not, Your Honor. Did not
You're able to put those in your complaint, so you're able to discern what those statements were because they're listed in the complaint, but they're not in the notice.
Well, at the time that the notice was drawn up, I had not had the opportunity to see the broadcast. The information contained within the broadcast had been relayed to me over a telephone call. I was in an airport across the country.
Okay, but there's not an exception for that in the statute, right? The statute says you shall give notice specifying the statements that were made that you claim to be defamatory, and that wasn't done in this case. For whatever reason, it wasn't done. Your paralegal, I think, drafted the cease and desist, but it didn't contain the specific statement that you claim to be false and defamatory. Isn't that fatal if your notice doesn't have that?
Well, it did, Your Honor. I mean, I would argue that it did. It refers directly to my notice and says, quote, "the statements by Todd Ulrich and Kathy Lerman, referring to myself in relation to Renew N Corp. That are contained within the broadcast."
What were those statements? In other words, well, let me rephrase that.
Yes, sir.
What specific statements made by Mr. Ulrich or anyone else in that broadcast did you set forth in that notice letter?
Well, they included 2 statements that were allegedly produced by the police, which in fact were not public records. WFTV has never produced them. They've never produced any evidence that they were public records because it doesn't exist. I, on the other hand, produced evidence that from both sheriff's departments that they in fact did not exist. They were actually created by WFTV and their editorial department or whatever department creates the graphics. 2 pieces of paper, 2 police statements are the only places in the entire broadcast that contain any reference to me whatsoever. So I think that...
Counsel, I'm sorry, what was the reference?
The reference to me, it was extensive. They referred to me as the criminal mastermind behind this Renewin. They claimed that I was the financier.
So why didn't you put those in the notice?
Because I didn't know specifically any of those allegations. Remember,
I mean, how long? So you sent them the notice, and you were on the road, and I understand what you're saying is that you couldn't at the moment look at and determine exactly what all the statements were, right? But how much longer? How much later was it that you filed the complaint?
2.5 hours. Oh, well, I filed the statement 2.5. I filed the notice.
But when did you file the complaint? It was some time after you filed, after you sent the notice.
It was, Your Honor, and I had gone and sought counsel and spoke to counsel.
Why didn't you just correct the notice? And wasn't it almost 2 years later that you filed the complaint?
Every attorney that I spoke to, and I spoke to numerous attorneys, all told me when I provided them everything I'd given them, they told me that I had satisfactorily met the standard for pre-suit notice. So, not one of them. I spoke to 7. and very reputable attorneys.
So the issue, your argument isn't that you didn't have time because you were on the road. That's kind of irrelevant. You're saying that you thought that your notice was satisfactory.
Well, no, Your Honor, it was relevant because I was trying to prevent them from running the story again on the 11 o'clock news, publishing it on the website, publishing it on Facebook. I was trying to prevent all of that.
No, but it's not relevant to whether or not that's sufficient notice, right? I mean, you know, in other words, it seems like you're arguing that your notice was sufficient in part because it was based upon the best information you had at the moment.
Best possible notice, just like Duffy.
But I guess my question is it seems like there was a whole lot of time in between the notice and the complaint. You could have supplemented the notice, but you're just saying that you thought that it was adequate, so you did.
I felt that it was adequate to do what the law says, or what the statute says it needs to do, which is it needs to notify the publisher of what I want removed, what I'm claiming is defamatory. And what I was claiming was defamatory is putting my name in any way, shape, or form in that broadcast. So you had to go and take me out of the broadcast completely. So here's the scenario. I filed my notice. I would have to assume the legal department, the editorial department, called TODD ULRICH and said, hey, we just got a notice from a guy named RODERIC BOLING, says he's going to sue us for your broadcast this afternoon at 5. Did you include him in the broadcast? Ulrich's answer has to be, yeah. Well, what part did you put him in? Oh, we cooked up 2 fake documents that said they were from a sheriff's department. He can't act like he doesn't know what I'm referring to. I'm referring to it clearly. Statements made by him and Kathy Lerman and others, because I don't know the names of the people who create the graphics. Whoever created that, those police statements, and put them in. Those statements, they need to come out. You need to take those out. It wasn't that they mentioned me scattered throughout the entire thing. It was important enough for them to create the documents, and then air them, and then make the timing of throwing the badges, graphics on top of them while he read his narrative about police investigations.
You're talking about this blurry document that shows up on the screen for a second that you can't even read unless you pause it at the right second. Is that what the record reflects?
Your Honor, number one, it's not blurry. It's not blurry at all. It's in high definition. It was on there for about 6 seconds, which may not sound like a long time, but when it says complaints have been filed with the sheriff's department, and then they superimpose badges on it, anybody wants to know what they say. You just hit pause and read it. Exactly what I did once I finally got it. Hit pause, read it, clears the bell. RODERIC BOLING, and it just goes on and on and on and on. It's the entire document. There's not one thing in there besides my name that has any truth to it at all.
Well, then why would you not, once you had a chance to see it, whether it was the next day, the next week, whatever it is, why would you not then say in a notice, these are the statements which I believe are defamatory, and these are the statements which need to be removed, retracted, whatever it is, as opposed to saying the statements?
Your Honor, it was because I felt that it isn't that you could remove some statements from there with me involved. It's that you had to remove me from the entire broadcast. If you run a broadcast about pedophilia, and then you introduce some guy's name that has nothing to do with it, the guilt by association, even though we don't have a false light claim anymore, the Supreme Court has decided that we still have a defamation by association claim. And in a defamation by association, you couldn't give a 770-01 notice of the false statements because you can have true statements that defame somebody. So how would I posit that? How would I say the true statements made me look bad, please remove them? They go, well, I'm not removing them, they're true.
Why didn't you at least say the statements in the documents that were put on the screen or something, identify that the statements are not something that the anchor said, but that it was statements about RODERIC BOLING in the document shown on the screen, something like that?
Your Honor, because the anchor never mentioned my name. The anchor, I know him personally, he knows me personally. I can call him on a cell phone. Hey, Todd, this is Roddy. Oh, hey, Roddy. So I know the gentleman. He knows he knows that I wasn't anywhere in there. He knows he had to craft those documents. He knows that I assume that they aren't real because they made them. And he knows where he put them tactically, he knows how he timed, he knows all
But the
of that.
statute doesn't say you provide notice unless the speaker already should know which statements are defamatory, right? It doesn't say that. It says identify the specific statements. You know, why didn't you at least say the statements about me in these documents?
I said the statements referring to me in the broadcast that related me to Renew N, and the only place that happens is in those fake police reports. That's the only place. The spirit of the law is give an honest media outlet an opportunity to correct so they can lessen the amount of liability. It isn't, and think about it, if you're trying to publish today's news and it's breaking news and you're under a time crunch and you have to make some decisions, there's going to be harmless error. But if you look at all of the rulings and you look at all of the cases, the Supreme Court always goes back to if it was harmless, if it was made with goodwill and good intentions and it was inadvertent error. None of that was the case here. This was willful, well thought out, it was crafted, and then it was run. For the person that crafted it to act as if they had not been notified of what was occurring is absurd to me.
The statute doesn't craft that exception onto it. In other words, it doesn't say unless they should already know or unless it should be obvious. You have to specify the broadcast, which seems to be there, but you also have to specify the statements which you allege to be false and defamatory. And to say everything about me isn't specific.
I didn't just say, Your Honor, everything about me. I specifically said the words, the statements, referring to statements made by Kathy Ulrich and Kathy Lerman and Todd Ulrich about me, which means all they had to do was go, what statements did Kathy Lerman and Todd Ulrich say about him? Where are they? They're right there. Okay, those are the things he's talking about.
Which means that you can say, here are the statements that you made about me, and you can specify them, as opposed to them going back and saying, well, all right, is this what he's talking about, or is that what he's talking about?
Your Honor, I told them to remove any reference to me from the broadcast. I didn't want them to remove one statement. I didn't want to remove.
Well, but what you want them to remove is not the standard, right? It's what is defamatory.
Correct. And introducing my name into the story, at that very moment, I was defamed.
No, I understand that's you know what your complaint said, but that's the merits. I mean, we have to get past this notice issue first. And the problem is the legislature makes the law here, not the courts. You know, the legislature says they write a statute and they say you gotta give notice. Our job is to try to interpret that statute. And so, based on this statutory language, how was your notice here that didn't even identify that the statement was made in the documents? How is that sufficient? How is it specific enough?
The statute is designed to ensure that the media outlet has an opportunity to correct. That's what it's designed for. It isn't designed to parse words and make people be hyper-specific about it. It's to get the media outlet to the right location, to the right material, so they can decide whether they want to take it out or leave it in. And in my case, they knew, all of them knew exactly what I was talking about because I told them. Anything referring to me, remove it.
There's a statement about you, just hypothetically, in that written statement that says, Mr. Boling lives in Central Florida, and then they have all the other stuff. You're saying remove every statement about me. If that's not a defamatory statement, why would they have to remove something like that that's not defamatory?
Because, Your Honor, they still included me in the broadcast. You can't take a broadcast about busting a ring of pedophiles and introduce some priest's name into it that has nothing to do with it and say he's been a priest for 20 years and just recite some facts and then expect that the defamation by association, which we recognize in Florida, it doesn't apply to it. So whether they are true facts or whether they are false,
Obviously, the concern in this case is, maybe not obviously, but the sufficiency or insufficiency of the notice that you gave. I understand why you did it so quickly. You wanted them to stop that broadcast from the news the next day or the next morning, whatever. But there was time then to amend or revise your notice to say, look, these are the statements, the specific statements I'm talking about, because the defamatory or the defamation, if it is defamation, is still ongoing. You say it's on the website, it's on the Facebook page, so you could have given them notice at some point and fixed your notice, right?
Well, Your Honor, I didn't want them to remove certain language. I wanted them to remove any reference to me. They reviewed it, and they just decided that they weren't going to do it. And here's the other thing. Very rarely, excuse me, just... Very rarely, and I could obviously find no cases related to it, can you find where someone gave them pre-publication notice. I was alerted that they were going to defame me. I called the broadcaster and said, do not put this material in your broadcast or I will sue you.
You can keep going, but you are into your 5-minute rebuttal now.
Yes, sir. So to me, that's incredibly relevant in this case because it is unique. For me to know what they're going to publish and for me to say, do not do it or I will sue you, and then they intentionally do it to act as if they don't know what I'm referring to is absurd. To me, it's offensive to the court to even write that we had no clue for 2 years what he was referring to. We were at a disadvantage. There were no disadvantage. If I tell you not to do something, and then you do it, and then I say you did it, you need to stop it, you don't go, I don't know what you're talking about.
The problem again, though, is that the statute doesn't make an exception for that. It doesn't say you have to give specific notice unless they're already aware of what you said because you talked to them beforehand.
I understand, Your Honor, but I'm not looking for the statute to say that. The statute says that the media outlet needs to be alerted to what I am talking about. And as long as the notice was sufficient for that media outlet to know what I was talking about, which I'm arguing that it does, then at that point in time, they've been noticed properly.
Well,
and I'll reserve the rest of it.
We have to say, did he make a specific statement, or did he identify the specific statements to be, that he claimed to be false and defamatory? The legislature tells us that's what has to be in the statute, or that's what has to be in the notice. So it doesn't address, well, I told them in advance, or I sent them a blanket cease and desist.
I understand, Your Honor. But the Supreme Court, in their ruling in Nelson, was very clear that the best possible notice was acceptable. And my argument is that not only did I provide them with the best possible notice, but I provided them with ample notice for them to be able to make a determination as to what Nelson versus Associated Press, 667 Federal Supplement 1468. The statute, quote, the statute requires the best possible notice. And I feel like that I gave them the best possible notice. They knew precisely what I was referring to. And they just simply elected to not redact it. Turns out it was all false, as I had said it was.
Wouldn't the best possible notice be similar to what you put in your complaint, where you go by line what they said?
No, sir, because it's the best possible notice when you read Nelson that you can get them at the time, because you're trying to prevent the damage.
Would you concede that it at least would have been better if you had identified that, if you had said that the statements you're talking about were in the documents?
Yes, sir, I would have.
I mean, that would have improved it, right? At least.
Yes, sir, I could have improved it in numerous ways. But I still would have insisted categorically that they remove any reference of me in association with that story.
Counsel,
I'll reserve my time.
You have about, okay. All right, counsel for the appellee, whenever you're ready.
May it please the court. Rachel Fugate on behalf of the Appellees, WFTV, and its reporter Todd Ulrich. Mr. Boling has sued WFTV and its reporter for defamation in connection with the broadcast that does not mention him. And despite
His name's not in those documents?
It is in the documents, which a screenshot was attached, was blurry, and in the complaint it says to read his name in those documents, you have to pause the broadcast. So just listening to the broadcast and watching the broadcast, if you do not pause it, He is not mentioned by name in it, and his picture is not shown in it. So the average viewer, not pausing the broadcast, would have never known that he was mentioned. He wasn't displayed
You can
in the
see that
broadcast.
some viewers might have known that he was mentioned because he was mentioned, right?
If you pause on the record as it flashed up, if you paused on the record and took the time to read what was in that record, you would read information about Mr. Bowling. But despite the tenuous nature of the underlying action and accepting all of the facts in the complaint as true on the motion to dismiss stage, which we must, the fatal flaw in his claims results from his failure to satisfy a condition precedent to filing suit and provide sufficient notice to WFTV pursuant to Section 770.01 of the Florida statute.
Well, counsel, he identified the broadcast, right? Can we agree
Yes.
that? I mean,
Yes,
so that,
absolutely.
we're good there. He
Yes, we are good there.
specified the broadcast.
Yes.
So then the only question is, did he specify the statements, right? The statute requires both specifying the broadcast and the statements. And he said, I mean, I'm looking at it right now. I mean, he says the statements regarding myself, Roderick Lee Bowling.
Yes.
So he said statements about Roderick Lee Bowling. Why isn't, he says that's enough. Why isn't that enough?
Your Honor, under the case law, it's not enough. You can't just generically say statements about me are false. The Orlando Sports Stadium case found, the fourth DCA found a notice insufficient. It identified the article at issue, but did not specify the statements therein alleged to be false and defamatory. The Gannett versus Montesano case.
What if he had said in his notice, every single statement that you make about me in the documents in this broadcast is false and defamatory, and I demand you to take them down? That'd be enough?
I think that would be a closer call if he identified the documents, because again, on the face
And
of
said every statement that you make about me in those documents.
I think that would be a closer call. But if you look at the complaint, he attached a transcript of what was in that record. He doesn't even challenge every statement about him in that record. It's a subset of those statements that he alleged to be false and defamatory in his complaint. What he did in his complaint is exactly what WFTV was entitled to. That is the best possible notice. If a person can pause and read all of this information about Mr. Bowling, that is what he's required to put in the notice. He is at the very least required to direct WFTV. Like, there is this broadcast, and even though I may not be mentioned on the face of it, if you look into this record that you showed for a few seconds and pause it, you can read all of this information about me. And these are the statements that I allege to be false and defamatory, which is exactly what he did in his complaint. And it is only a subset. There are many statements that are contained in his transcription, which is part of the record at 114. If you compare those to the allegations in the complaint, it's only a subset of that. There are many statements in that transcription about Mr. Bowling that he doesn't challenge. So what WFTV was entitled to, according to the statute, and there are two parts of it. You have to identify the broadcast at issue and the statements therein alleged to be false and defamatory. If this notice was sufficient, you're basically rewriting that part out of the statute. That statute is clear and unambiguous. All of the case law interpreting this requires specificity on both parts. In the Gannett versus Montesano case,
Is there any case that you're aware of anywhere that takes the statute and then says, but there's an exception if the speaker already knew?
No, Your Honor. None. It's a condition precedent to filing suit. It's very specific. All of the cases require that specificity. There is no exception for, well, if they already knew, then they are on notice. There is no case stating that. And actually, in the Ross versus Gore case, and even this court in the Commons versus Van Voorhees case said, well, maybe you just limit them to actual damages. And the court says, no, that defeats the purpose of the statute. That's rewriting the statute. The statute has the specificity requirement with particularity, and it is a condition precedent that must be fulfilled prior to initiating the action and within the statute of limitations. Mr. Bowling had 2 years to provide the kind of notice that he did in his complaint. He filed his complaint on the very last day of the statute of limitations. So at that point, it would have been impossible to provide notice in compliance with the statute. So any attempt to refile or amend would have been futile. So dismissal in this case with prejudice was warranted because of that ensuing 2-year period. If Mr. Boling had not waited so long to file his complaint, this issue would have been raised. Perhaps he would have still been in the statute of limitations and could have amended a notice or refiled and provided that notice. But it was his choice to wait till the very last day of the limitations period to file suit, and he did so without adequately complying with the notice provision found in Section 770.01. The first DCA in the Gannett versus Montesano case, I think that case is especially instructive. There, the notice attached the article at issue and claimed that it was false and defamatory because it imputed a crime to the plaintiff. So there, you actually have more specificity than what Mr. Boling did here, and the court there found that that was insufficient. In all of the cases that describe insufficient notice, in most of them, the article or broadcast is identified, and of course the plaintiff says, and you published false statements about me. All of the cases say that is simply not enough. The Duffy case, which Mr. Boling mentioned, there the plaintiff attached a link, the broadcasted issue, and said statements therein basically accusing us of stealing or being a thief. So the court allowed them to proceed on statements that they were stealing or that they were thieves. So again, you had some connection to the defamatory statements that the court allowed them to proceed on. And again, in this case, the best possible notice here would have been to do exactly what Mr. Boling did in his complaint. He had 2 years to do so, and he chose not to. And he chose to do so in the complaint instead of notice, and on the very last day of the statute of limitations. That problem is incurable because now he cannot provide notice within the statute of limitations and have a viable claim. Therefore, the trial court was correct when it dismissed Mr. Boling's claims with prejudice, and that order should be affirmed. And unless the court has any additional questions?
Thank you, counsel.
Thank you very much.
Okay, Mr. Boling, you have a minute 55 left, and I won't start it until you start your argument.
Thank you, George. The defendant continues to repeat that it was illegible, it was blurry, it was this, it was, well, my question would be if that were the case, why even include it in the broadcast? Why go to all the work to craft it and make it and place it?
I think they conceded that if you pause, that if someone paused it, they could read it.
Well, I don't know how often you DVR stuff, but I can tell you humanity nowadays, the younger generation than me, and including myself, we did DVR and pause all kinds of things. If you want to see it, watch it again, and the minute you hit it, you can read it clear as a bell. When she says that I listed each and every defamatory statement and that I left out a bunch of stuff, I didn't leave out anything. I said in my complaint that associating me in any way in the complaint with Renewin, I was instantly defamed. The moment that you said Roderick Boling and Renewin, just the moment that you said, you know, John Doe and his buddy Ted Bundy, immediately you have associated that man with a serial killer. So when you say remove anything that associates me with Mr. Bundy, take my name out of it. If you don't know where to go to the place you find my name, remove it all. And they went, no, they've elected not to do it. The next is, when they connected me, and I specified in my notice that relating me to Renewin, that any reference to me in Renewin was defamatory. So there's one specific piece. I also included in it not just the statements, but associating me in any way with Renewin. So they can't say that I didn't refer to another party, or I didn't refer to some part of the association. And again, in Duffy v. Fox News and in Nelson v. Associated Press, both of them accepted the notice without the specificity requirement. I believe that I was plenty specific to put them on notice.
Counsel, you are out of time. If you want to wrap it up.
I am. I believe that the notice was sufficient, Your Honor, and I think that's about it.
All right, thank you very much.
Appreciate it.
Okay, I neglected to